card options: EB-1, EB-2, and EB-3. As with the non-immigrant status, there are several options for professors and researchers that are seeking permanent residence. While each option is designed for specific circumstances, many individuals will qualify for more than one employment-based green card category. Let's look at some employment-based green card categories for permanent residence in the U.S. EB-1 green card option, the EB-2 for outstanding researchers and professors. Outstanding professors and researchers are individuals that are recognized internationally for their outstanding academic achievements in a particular field. In addition, an outstanding professor or researcher must have at least 3 years of experience in teaching and research in their academic field and must be entering the U.S. to fill a tenure or tenure-track teaching position or a comparable research position at a university or other institution of higher education or a private organization. If the employer is a private company rather than a university or educational institution, the department, division, or institute of the private employer must employ at least 3 persons full-time in research activities and must have achieved documented accomplishments in an academic field. The employer must file a petition for an outstanding professor or researcher. Let's look at the initial evidence required. Employment-based green card petitions for outstanding professors and researchers must be accompanied by sufficient evidence to show that the professor or researcher is recognized internationally as outstanding in the academic field specified in the petition. Such evidence shall consist of at least 2 of the following categories. Number 1, documentation of the alien's receipt of major prizes or awards for outstanding achievement in the academic field. Number 2, documentation of the alien's membership in associations in the academic field which require outstanding achievement of their members. Number 3, published material in professional publications written by others about the alien's work in the academic field. Such material shall include the title, date, and author of the material, and any necessary translation. Number 4, evidence of the alien's participation, either individually or on a panel, as the judge of the work of others in the same or an allied academic field. Number 5, evidence of the alien's original scientific or scholarly research contributions to the academic field. Or, number 6, evidence of the alien's authorship of scholarly books or articles found in scholarly journals with international circulation in the academic field. The petitioning employer must also provide evidence that the alien has at least 3 years of experience in teaching and or research in this academic field. Any experience in teaching or research gained while working on the advanced degree will only be acceptable if the alien has acquired the degree and if the teaching duties were such that he or she had full responsibility for the class taught, or if the research conducted toward the degree has been recognized within the academic field as outstanding. Evidence of teaching and or research experience shall be in the form of letters from current or former employers and shall include the name, address, and title of the writer and a specific description of the duties performed by the alien. Finally, outstanding professors and researchers require an offer of employment as initial evidence in support of a first preference employment-based green card petition filed on their behalf. The offer of employment may be in the form of a letter from the petitioning employer, such as the U.S. university or institution of higher education, or a department, division, or institute of a private employer, must state that the employment is a tenure or tenured track teaching position or a, quote, permanent research position in the alien's academic field. The word permanent in reference to a research position is defined by the USCIS as either tenured or tenured track or for an indefinite or unlimited duration, and in which the employee will ordinarily have an expectation of continued employment unless there is good cause for termination. If the employer is a private organization, it must demonstrate that it employs at least 3 persons full-time in research positions, and that it has achieved documented accomplishments in this academic field. A recent review of modern business practices reveals that most employment agreements for professors and researchers provide that a tenure-track teaching position or comparable research position is terminable quote, at will, end quote, even though both the employer and the employee have the expectation that the employee will continue in the employment for an indefinite or unlimited duration. Good cause for termination clauses are often not included in such agreements because they raise numerous legal and business issues for employers. In determining whether a petitioning employer has established that a research position is permanent, some USCIS adjudicators have focused solely on whether the language of the actual employment contract, if submitted, or the offer of employment contains a, quote, good cause for termination, end quote, provision. The petitioning employer, however, must still establish that the offer of employment is intended to be of an indefinite or unlimited duration and that the nature of the position is such that the employee will ordinarily have an expectation of continued employment. All right, let's look at a case. For EB-1 to professors and researchers, an offer of a permanent employment is met when there is an intent for ongoing employment. Does an individual whose employment is renewed annually meet the requirement for an offer of permanent employment based upon the mutual expectation the offered employment will be extended on an ongoing basis? Probably not. In these cases, in the case of researchers, the petitioner must establish that the job is permanent. The regulations require that a petitioner submit evidence that the position is tenured, tenure track, or for a term of indefinite or unlimited duration, and in which the employee will ordinarily have an expectation of continued employment unless there is good cause for termination. The mere fact that the petitioner claims that the job may be renewed annually is not sufficient to establish the permanent nature of the job. EB-1 green card options. Let's look at the EB-1, aliens with extraordinary ability. Professors and researchers, or any other person on their behalf, may file a Form I-140 petition for an employment-based green card as an alien of extraordinary ability in the sciences, arts, education, business, or athletics. Extraordinary ability, as defined by USCIS, means a level of expertise indicating that the individual is one of the very small percentage who have risen to the very top of their field of endeavor. The initial evidence, an employment-based green card petition for an alien of extraordinary ability must be accompanied by evidence that the alien has sustained national or international acclaim and that his or her achievements have been recognized in the field of expertise. Such evidence shall include evidence of a one-time achievement, that is a major internationally recognized award, something like the Nobel Prize, or at least three of the following. 1. Documentation of the alien's receipt of lesser, nationally or internationally recognized awards or prizes for excellence in the field of endeavor. 2. Documentation of the alien's membership in associations in the field for which classification is sought, which require outstanding achievements of their members, as judged by recognized national or international experts in their discipline or field. 3. Published material about the alien in professional or major trade publications or other major media relating to the alien's work in the field for which classification is sought. Such evidence shall include the title, date, and author of the material, and again, any necessary translation. 4. Evidence of the alien's participation, either individually or on a panel, as the judge of the work of others in the same or an allied field of specialization for which classification is sought. 5. Evidence of the alien's original scientific, scholarly, artistic, athletic, or business-related contributions of major significance in the field. 6. Evidence of the alien's authorship of scholarly articles in the field, in professional or major trade publications or other major media. 7. Evidence of the display of the alien's work in the field at artistic exhibitions or showcases. 8. Evidence that the alien has performed in a leading or critical role for organizations or establishments that have a distinguished reputation. 9. Evidence that the alien has commanded a high salary or other significantly high remuneration for services in relations to others in the field. Or 10. Evidence of commercial successes in the performing arts as shown by box office receipts or record, cassette, compact disc, or video sales. Let's please note, not all of the above categories will fit or be applicable to all professors or research positions. If the above standards do not readily apply to the beneficiary's occupation, the petitioner may submit comparable evidence to establish the beneficiary's eligibility. No offer of employment is required. Foreign nationals seeking classification as persons of extraordinary ability do not need to have an employer in the U.S. They can self-petition. However, the employment-based green card petition must be accompanied by clear evidence that the alien is coming to the United States to continue to work in that area of expertise. Such evidence may include letters from prospective employers, evidence of prearranged commitments such as contracts, or a statement from the beneficiary detailing plans on how he or she intends to continue his or her work in the United States. Let's look at some relative advantages of the EB-1 green card options for aliens with extraordinary ability. The main advantage of the extraordinary ability category, when compared to the outstanding professor or research category, is that the extraordinary ability alien is not required to be employed and may self-petition. Professors and researchers must, however, demonstrate that they are planning to work in their field of expertise. Further, an extraordinary ability alien who is sponsored by an employer may take advantage of an improved immigrant visa petition under this classification, if he or she chooses to change employers, without having to rely on the portability provisions of AC 21, as long as the alien can prove that he or she plans to work in the same field. Other employment-based green card categories. The EB2 and the EB3 green card categories are also viable options for professors and researchers who cannot satisfy the eligibility requirements as outstanding professor or researcher, or as an alien of extraordinary ability. Let's start with EB2 green card for professionals with advanced degrees or persons with exceptional ability. The EB2 employment-based green card classification includes aliens who are members of the professions holding advanced degrees or their equivalent, and aliens who have exceptional ability in the sciences, arts, or business. For purposes of this section, advanced degree means any United States academic or professional degree or a foreign equivalent degree above that of baccalaureate. A United States baccalaureate degree or a foreign equivalent degree, followed by at least 5 years of progressive experience in the specialty, shall be considered to be the equivalent of a master's degree. If a doctoral degree is customarily required by the specialty, the alien must have a United States doctorate or a foreign equivalent degree. In order to be classified as a person having exceptional ability in the sciences, arts, or business, the individual must provide documentation of 3 of the following. 1, an official academic record showing that the alien has a degree, diploma, certificate, or similar award from a college, university, school, or other institution of learning relating to the area of exceptional ability. 2, letters documenting at least 10 years of full-time experience in the occupation being sought. 3, a license to practice the profession or certification for a particular profession or occupation. 4, evidence that the alien has commanded a salary or other remuneration for services which demonstrate exceptional ability. 5, membership in professional associations. Or 6, recognition for achievements and significant contributions to the industry or field by peers, government entities, professional or business organizations. Note, if the above standards do not apply to the petitioner's occupation, other comparable evidence of eligibility is also acceptable. Let's take a quick look at a case. Chen is a Chinese national who has a PhD in biological statistics. He has just been offered a tenure-track position with a Southern California university to teach advanced statistics and to provide statistical support to their cancer research department. Chen has an extensive resume after only 5 years in the field. He has written numerous articles about biological statistical methods. In fact, the methods he developed for his PhD research in the field have been adopted by many and have been praised as some of the most innovative and groundbreaking research presented in years. Chen is also a reviewer for several scientific journals and has written numerous articles in his field. At his last position, he was named as one of the members of the development team that received a patent on the work they were doing. What options does Chen have? Given the strength of his background, he should qualify for several categories, including an individual of extraordinary ability, the EB-1, an outstanding professor or researcher, the EB-2, an individual with an advanced degree in the EB-2, using either the university's, quote, special handling, end quote, procedures, or seeking a national interest waiver, and clearly as a professional in the EB-3 category. Let's look now into labor certifications and waivers. The EB-2 employment-based green card petitions must generally be accompanied by an approved individual labor certification from the Department of Labor. The labor certification must outline the minimum requirements for the position and is proof that there are no minimally qualified U.S. workers that are ready, able, and willing to fill the offered position. Colleges and universities that are seeking labor certification for a professor and certain researchers can take advantage of the special handling rules. These rules allow the educational institution to show that the foreign national is more qualified, minimum qualifications do not apply, than other applicants, and document that the alien was selected for the job opportunity in a competitive recruitment and selection process. They can use the recruitment process for the position as long as it was within 18 months of the time the labor certification application is filed. If you are a worker with an advanced degree or you meet the exceptional ability requirements, you may apply to waive the requirement that you have a job offer if such a waiver would be in the national interest. The USCIS established a three-part test for the national interest waiver. You must show that 1. The person seeks employment in an area of substantial intrinsic merit. 2. The benefit will be national in scope. And 3. The national interest would be adversely affected if a labor certification were required. Having met the exceptional ability standard by itself is not sufficient to gain the waiver. The USCIS has held that work such as local pro bono lawyering, teaching in a single school, or providing nutritional information in a localized setting is not sufficient to meet the national criteria. Additionally, a national interest waiver is not warranted solely to ameliorate a local labor shortage. The petitioner must prove that the benefit his unique skills would provide substantially outweighs the inherent national interest in protecting U.S. workers through the labor certification process. A national interest waiver must also be accompanied by a completed Department of Labor Form ETA 9089. One of the greatest benefits of the national interest waiver application is that the foreign national, as with the EB-1 category, can self-petition. Let's go now to the EB-3 green card category for skilled or professional workers. A category that will not be overly utilized for professors and researchers, but which nonetheless should be considered, is the EB-3 employment-based green card for skilled workers, professionals, and other workers. While eligibility requirements for the EB-3 green card classification are less stringent than the EB-1 and EB-2 green card classification, one should be aware that a long backlog exists for visas in the skilled workers, professionals, and other worker category. The EB-3 green card classification includes aliens with at least 2 years of experience as skilled workers, professionals with a baccalaureate degree, and other workers with less than 2 years experience, such as an unskilled worker who can perform labor for which qualified workers are not available in the United States. Skilled worker positions are not seasonal or temporary and require at least 2 years of experience or training. The training requirement may be met through relevant post-secondary education. The labor certification application states the job requirements, which determine whether the job is skilled or unskilled. Professionals must hold a U.S. baccalaureate degree or for an equivalent degree that is normally required for the profession. Education and experience may not be substituted for the degree. Other workers are in positions that require less than 2 years of higher education, training, or experience. However, due to the long backlog, a petitioner could expect to wait many years before being granted a visa under this category. Concluding now, when it is time to take that final step to permanent residence, professors and researchers and their educational and/or research-oriented employers have several employment-based green card options to choose from. They and their counsel must carefully study all the facts of their case to determine which employment-based green card category they may qualify for, and then develop a strategy to reach that ultimate goal, the green card. In some instances, the individual will meet the basic requirements for 2 or more employment-based green card categories. In those cases, we often recommend that the individual pursue all options concurrently. But depending on the strength of the application for each option, we may suggest that the individual initially seek only the category they are the strongest in. In recent cases, VisaPro has used all of the above employment-based green card options in helping clients. If the university completed a competitive recruitment within the last 18 months, and it is likely that the individual will be remaining with the university for some time, we would usually recommend that they use the special handling labor certification rules because it is the surest route. If the researcher is clearly one of the top people in his field whose services are highly sought after, i.e., they may change employers, then the extraordinary ability petition would get the nod. If that same person is working on research that will substantially impact his field in the future, we may suggest the national interest waiver petition as well. Again, it all depends on the facts of the case. Contact VisaPro if you have any questions regarding any type of business or work visa. Our experienced attorneys will be happy to assist you.